Hello, everyone. Good evening in Japan and good morning in Europe, maybe. Thank you very much for joining this web conference. This conference is jointly organized by the Japan Institute for International Arbitration Research and Training, or JIIART, and Chuo University. And also the Institute of Comparative Law in Japan at Chuo University is supporting to this conference. I'm Chuck Ito, a director at the Institute of Comparative Law. Soon will step down. I'm so sorry. At first, my colleague Shin-Ichiro Abe, the chair of the JIIART and adjunct professor at Chuo University Law School, will provide a welcome message to you. Shin?
Thank you. Hello, everyone. Thank you all for joining Zoom Symposium to celebrate the inauguration of JIIART. I'm Shin-Ichiro Abe, the chairman of JIIART's board of directors. As Japanese business begin to encounter international arbitration increasingly in today's world, there are more and more Japanese seeking information and training on international arbitration. The purpose of our institute is to meet this need. As a part of our aim to be an extensive resource on international arbitration, we regularly post information on our institute homepage regarding symposium and other events held by various international arbitration centers, such as the ICC, as well as by the arbitration institutions of inside and outside of Japan. Our hope is that by doing so, our institute's homepage will serve as a gateway to the various arbitration events going on around the world for anyone who is interested in learning about international arbitration. In terms of training and education, a wide range of topics will be taught, from the basic procedure to the latest issue trending in international arbitration regime. At our institute, we would like to drive the study of international arbitration forward ambitiously together with all of you. As to specific initiatives, we have in mind tie-ups with universities such as Chuo University and other institutions to provide programs on arbitration. We are also aiming to hold seminars and symposiums with renowned professionals in the field of arbitration. In addition, we are also planning opportunities for young people to interview preeminent academics and practitioners in arbitration world in order to gain insight into international arbitration. Also on education, we believe that taking part in overseas symposium and events is an excellent learning experience for young lawyers, especially for those who have never participated in such a symposium. And so, our institute also aims to provide support to gain speaking opportunities for the young lawyers who come to our institution to learn. These are just some of the ways our institute aims to provide information from around the world and training on international arbitration. With the cooperation of arbitration institutions around the world, we at our institute hope to help all of you who are interested in international arbitration to develop your skills in this area. We are looking forward to seeing you all succeed as future arbitration professionals. Thank you.
Thank you, Shin. Now I am very, very pleased to introduce Dr. Jan Groteer from Hamburg, Germany. Dr. Groteer has been a president of German-Japanese Lawyers Association, Deutsch-Japanische Juristenvereinigung, DJJV, for a long time. He has tremendously and enthusiastically contributed to the comparative law area, both in academics and practice between Germany and Japan. Jan, are you ready? Could you give a message to us, please?
Yes, thank you very much for warm words. And I am very honored by the opportunity to say some words today and to also extend warm greetings on behalf of the German-Japanese Association of Jurists to you. What do I have to say to you? A retired judge like me normally has not too much to do with international arbitration and mediation. In my case, however, I had a lot of contacts, especially with Japan, but also with Taiwan, Korea, and Vietnam. And these contacts were followed by requests from the Chamber of Commerce Hamburg and ICC Paris to work for them as an arbitrator. During the time in which I had a lot of contacts with Japan, I was a participant of an exchange program for judges between Japan and Germany and had the chance to work at the Supreme Court of Japan for 2 months and was later one of the founders and for 25 years the president of German-Japanese Association of Jurists. All this hopefully gives me some legitimation to say a couple of words here on this very interesting and important opening seminar of Japan Institute of International Arbitration Research and Training. In my opinion, it was a highly useful and even necessary idea to found this institute and to start a seminar especially for young lawyers. I would like to emphasize 2, for me, important thoughts. Young lawyers in Japan should gain access to international arbitration and acquire knowledge and information about this very important topic. That means for me that not only the Japanese universities should provide a focus on international law and ADR, but also legal training and research institute. And my hope and wish is that in the future, global law firms will not only have headquarters in the US and Britain, but in Japan too, and by the way, in Germany as well. That, in addition, would also mean better access to international arbitration cases. And secondly, I would like to highlight that Japan, as one of the most important economies in this world, should become a hotspot for ADR in Asia. That means that Japan should build up an organization or brush up the Japan Commercial Arbitration Association for international arbitration cases, which we have, for example, in Paris, New York, London, and Singapore. And let me finish with my conviction that the global economy will be revived after Corona, and this will bring along a lot of new arbitration cases. And at the very end, I would like to encourage all the young lawyers who participate today to work on ADR. All aims can only be reached by the first step. Perhaps the seminar today might be the first step for you. Thank you very much.
Thank you very much, Jan. It's a very, very ambitious words. Thank you so much. So now I'll be able to turn to the opening remarks. The first lecture is conducted by Professor Colin Ong, QC. He is highly experienced as barrister, lead counsel, and arbitrator in a large or complex international commercial disputes. Dr. Ong is the first ASEAN national lawyer appointed to be a Queen's Counsel in England. Today, he is going to talk about a very, very interesting topic, artificial intelligence and technology in the COVID-19 era. Colin, are you ready?
Thank you very much, Professor Chuck Ito, for the kind introduction. Professor Shin-Ichiro Chairman of JIIART, esteemed colleagues, Justice Anselmo Reyes, ladies and gentlemen, it is an honor for me to be able to deliver the keynote opening remarks. When the COVID-19 pandemic first struck the world, everyone had difficulty in adjusting to the situation. Most of us have now adjusted to the new normal. So the new COVID era, which we normally call the new normal, is still quite strange to many of us, but we have adjusted. The pandemic has indeed had a very major impact on individuals, businesses, and countries. The practice of international arbitration has changed greatly. We arbitration practitioners have adapted the way in which we work in the light of difficulties caused by COVID. Remote hearings, virtual hearing protocols, and technology, including remote advocacy, are now the new norms. The COVID era has indeed fostered digital transformation to deal with the new complexities. Intelligent assistants and technology platforms such as EPIC and Opus are the new norms in international arbitration. Indeed, we would not be able to function without these sort of technological platforms. Tribunals still face dilemmas where only one party to an arbitration is in favor of holding a virtual hearing and the other side objects to it. Until the first test cases were decided in courts around the world in April this year, many tribunals took the more cautious approach and tended not to allow virtual hearings where one party strongly objected to the same. This whole approach to arbitration and advocacy has now changed. Practitioners have already learned to adapt to this technology, and indeed, we find it the new norm, and it would be strange for quite a few of us now not to use such technology. The daily use of online streaming and video conferencing tools is something that we take for granted now. Such tools also support new techniques such as asynchronous arbitration, where things do not occur at the same time. There is increased interest and usage of technology, intelligent assistance, and artificial intelligence in being applied to arbitration cases. As many lawyers now work from home, lead counsel no longer have the luxury of being surrounded by junior lawyers to assist in document management, both for case preparation and for hearings. Indeed, lead counsel now have to rely upon themselves to check through and put the finishing touches to e-hearing bundles and to conduct last-minute online research when faced with new positions or statements of law put in opposing opening statements. In the rest of my talk, I plan to highlight some of the key points of interest in how artificial intelligence has made an inroad into our profession as arbitrators and advocates. I shall then raise some provocative questions on how this increasing use of artificial intelligence in international arbitration in this COVID era can have profound effects, some of which unexpected. First, a quick introduction to the difference between intelligent assistance and artificial intelligence. Intelligent assistance refers to the use of programs that help humans perform tasks or services within predefined parameters. They would not go beyond what has been programmed into the system. Artificial intelligence is a field of computer science that seeks to create intelligent machines that can behave and react like humans. So artificial intelligence machines mimic humans, while intelligent assistance machines assist humans. In short, artificial intelligence algorithms can learn and self-improve. Artificial intelligence machine learning for document disclosure is already taking place in high-value international arbitrations. The current technology that's been used in arbitration is mainly focused on efficiency and streamlining the arbitration process. most of the software still do not fully utilize the full capabilities and potential of artificial intelligence. Let me run through some of the programs which a lot of you will be familiar with, those who are involved in arbitration. First of all, Opus 2 provides a hearing presentation platform and live transcripts. Epic Global also provides real-time hearing platforms and live transcripts with searchers and also live interpretation. Novos Arbicum provides a full solution to case management systems for international arbitration. Relativity One is a complete platform for e-discovery. Nuix can extract information from unstructured data. Algorithms already challenge what was once the exclusive domain of quantum experts. Algorithms can assist in analyzing time schedules, identify delays, and analyze any critical delay impacts. They also offer analysis on causation. However, all of the aforementioned technology platforms that I have mentioned are intelligent assistance tools, but not pure artificial intelligence algorithms. I shall now deal with the algorithms that are closer to advanced artificial intelligence algorithms. The software called Text Foresight can assist decision makers and lawyers alike in going through case law and look at issues, especially in the area of immigration, pension benefits, and taxes. The software can analyze thousands of judgments to predict how judges might rule on a certain set of given facts about the taxpayer's affairs. And it has an accuracy rate of 90%. So this is very helpful for litigation strategies and for counsel to predict how they should put their case forward. The aptly named software Litigate is a learning algorithm. It refutes arguments and suggests counter-arguments and recommends procedural steps that one may take in the High Court applications. One should also highlight the increasing usage of predictive coding. Predictive coding essentially is a mechanism where the AI algorithm learns from human reviewers. It is used primarily in cases where you have to deal with disclosure of documents, which can go up to hundreds of thousands of documents or even a million or millions of documents. Samples of such documents that are considered relevant are filtered and they are batch tested and then fed into the system, which then extracts key concepts. The system then applies them to the full database, and it then selects another batch of documents that it considers relevant. A lawyer without any knowledge of what has been tagged by the system then reviews and feeds on his review back to the system. And this process continues until the proportion of the relevant documents are deemed to be extremely high and accurate. Pyro Investments versus MWB Property in 2016 was the first UK case to consider the use of predictive coding for electronic discovery. The parties in that case had identified that the number of documents to be reviewed was in excess of 3 million documents. The estimated legal costs of reviewing those 3 million documents was in the area of several million pounds. So the parties discussed amongst themselves and decided to use what was then the innovative technology of predictive coding, subject to the High Court's approval. The estimated cost was between £180,000 to £470,000. So in the light of this, the High Court allowed predictive coding and therefore broke new ground. And now predictive coding is indeed being used more regularly in cases, high-value cases with a lot of documents. Let me now deal with trends in which artificial intelligence will make more inroads into international arbitration practices. Artificial intelligence is now used in cross-border investigations to review information taken from different sources, ranging from mobile phone applications to emails and any documents. The mechanism, the algorithm, spots keywords and sequences in data, analyzes the information, and then assembles a set of conclusions. In some countries, security agencies and police routinely use street cameras to perform face scans onto entire crowds of people to try to identify the identity of the individuals on the street. Another program that's making inroads is one that's aptly named LawGeeks. This algorithm essentially reviews documents, and it is able to review documents so quickly that it can approve a contract for signing on the spot. LawGeeks, artificial intelligence, had trained on tens of thousands of documents using machine learning technologies. And how fast was it? So in a test in which 20 experienced US lawyers were pitted against LawGeeks' AI algorithm, the challenge was focused on dealing with reviewing 5 non-disclosure agreements. It took an average of 92 minutes for the lawyers to review 5 NDAs. LawGeeks took 26 seconds to review the same number of documents. The 20 human lawyers registered an average accuracy rate of 85%, while LawGeeks' best accuracy rate was 94%. So one can see that technology, like it or not, has already made an inroad into the lawyer's domain, and it will continue to press on deeper. Now, there's been much discussion taking place in conferences all over the world as to whether artificial intelligence can eventually replace a human arbitrator. And the arguments for this are mainly that the algorithm is both independent and impartial. It cannot be bribed. It has no emotions. It is unbiased in the human sense. Artificial intelligence removes any possibility of sympathy bias. It reduces the possibility of clerical error. Indeed, the machine does not rest. The algorithm can deal with voluminous documents at a very fast pace, and it will not get confused with the facts of the case. However, there are hidden dangers that lurk within, and these have to be considered. Firstly, one would not be able to consider the track record of algorithm arbitrators. In investment treaty arbitration, it is quite known, some arbitrators are deemed to have pro-state views, while others are deemed to be pro-investor in their mindset. In common commercial arbitration, some parties look for black letter law, common law arbitrators, while others look for civil law arbitrators who are able to apply civil law concepts of hardship and fairness, or at least have a different perspective and approach, even if they're dealing with common law governed arbitrations. Question is, can the programming of artificial intelligence algorithms work equally well in dealing with both civil law matters and common law matters? There are hidden dangers of issue bias being programmed into the artificial intelligence algorithm. So the algorithm is neutral, the algorithm is independent, but who has programmed that algorithm? That comes into place. Also, the algorithm may not have learned new concepts. As such, it will have to be reliant upon old concepts and outdated learning. So unless you update the algorithm constantly, it may not be able to pick this up. But if the algorithm is self-learning, how then do you update it? Because each algorithm would have self-learned at a different pace and a different rate. So back to the concerns of algorithms having a cultural law bias, cultural legal bias. Currently, legal software for research and work tools for lawyers tend to be more inclined towards common law principles of case precedent rather than civil law jurisprudence. So how does artificial intelligence algorithm, how does it apply and decide cases pertaining to principles of, for example, ex eque et bono, or fairness principles, which form the bedrock of civil law? So these are important questions which need to be looked into carefully. The cornerstone of international arbitration is confidentiality. But if you have to train an algorithm for it to learn, how does that account for breaches of confidentiality? Because for the artificial intelligence algorithm to be able to get to a state where it can mimic a human, you would need to feed hundreds, if not thousands, of awards into the memory system of the algorithm. How does one deal with that? And one still has to input the data. Electronic evidence relies on the availability of metadata. But images and words can then be easily manipulated by counsel. If one changes the searchable overlay of a PDF by changing certain words or certain names, then these words and names will themselves not show up in searches. In short, one witness would have disappeared. And obviously, there is always the contention between a rigid artificial intelligence program as an arbitrator versus a more humane or human interpreter of the law. So what would happen then? Would arbitration then, the game change? Would the new game be to practice case theories against artificial intelligence programs from the outset to see what the conclusion would be, and then to change the case theory to try to get a different conclusion? Could that happen? Well, it could very likely happen if counsel deems that there's no way they can win on a certain case theory. And the question is, does artificial intelligence simply mimic reasoning abilities without actually having the ability to truly reason independently? Or does it, will it eventually have such capabilities? Currently, this is not yet the position. And because you need a person or a team to input data into the program in order for the algorithm to learn and absorb and to be able to mimic a human, the issue of independence and impartiality shifts away from a human arbitrator to the person who inputs the data and programming. So one will then start to think about what about the impartiality of the unknown programmer? What happens there? And if there should be a malfunction of artificial intelligence, who then should bear the negligence? Can one regulate liability issues surrounding artificial intelligence? If the developer could be sued under tort law, which jurisdiction takes jurisdiction? Would it be the courts of the domicile of the developer of the artificial intelligence, or would it be the courts of the domicile of the end user? These are very important questions to bear in mind. And can one truly foresee the harm caused by the algorithm? Because true artificial intelligence allows the algorithm to learn from past experiences. So how then can a developer be deemed to be responsible if the artificial intelligence does its very job and ends up learning more than at the time when it left the factory? Reinforcement learning also allows artificial intelligence to decide the best choice solutions to any given problem. If so, then can the artificial intelligence algorithm be deemed to be negligent? And then who decides the minimum quality standards of artificial intelligence arbitrators? Someone or would still have to decide the same. And would younger lawyers be stifled and stymied in growing up? Would they hesitate to take a different view if artificial intelligence evolved to become extremely accurate? Would they always defer to what the machine says should be the predicted outcome. A study in 2017 claiming that artificial intelligence can infer sexual orientation simply based on facial images alone caused the media uproar. The media uproar was then increased when artificial intelligence also claimed to be able to measure human intelligence and the likelihood of criminal inclinations of people simply by looking at facial images alone. Should there be ethical boundaries then? And how would one know whether such boundaries have been programmed into artificial intelligence robots? What happens if different regulators from different countries wish to take jurisdiction? Now, my personal view for now is that artificial intelligence arbitrators will not replace humans for now until such time that the technology improves, because humans like to interact with humans. Artificial intelligence cannot compete with humans in certain areas. They cannot detect non-verbal human actions. As advocates and arbitrators, we look at both the answers coming out from the mouths of the witnesses, but also the body language of the witnesses. Hesitant pauses in giving evidence during cross-examination, fidgety fingers, color changes to the face, dilation of pupils, all of this can have an impact. It can highlight certain things, both to the arbitrators as well as to opposing counsel who is conducting cross-examination. And then when you have a situation where you have 3-member tribunals, we know that 3-member human tribunals will often discuss in full and try to see if there's any possible compromise in differences which are not too great. How does one do this with 3 different artificial intelligence machines? Each have been programmed to rigidly stand its ground and come up with logical reasoning. They would not be able to do this. So I believe that at the end of the day, there is a difference between being clever and being wise, and the latter falls for the human arbitrators as an advantage. Experience, human interaction, and advocacy skill still plays a big part in international arbitration. However, as of today, no one, except maybe for some politicians, have any idea as to how long this COVID era will last. We do not know whether we would be able to travel to conduct arbitrations next year, or indeed for some time to come. We will continue to work on tech-supported platforms, such as this very Zoom session that is taking place right now. Many lawyers will continue to work alone at home. They will need to rely more on intelligent assistance and technology. And obviously, artificial intelligence can be a very helpful tool, and one should embrace it. Ladies and gentlemen, thank you very much for your attention. Thank you.
Impact of, sorry, thank you very much, Colin. It's very informative and huge impact of new technology on practice with a little bit danger and risks. So we still have to continue the comparative study and deep learning of human nature as well. Thank you very much. Yeah, let me introduce the next keynote speaker, Justice Anselmo Reyes. He's currently an international judge at the Singapore International Commercial Court. After 10 years experience in the Hong Kong High Court, he has been invited to professor at the University of Hong Kong. Justice Reyes has a visiting professor position in Japan as well. For example, Chuo University here, and Keio University in Tokyo, and Doshisha University in Kyoto. Today he will touch about the topic, building capacity in Japan for international commercial arbitration. Anselmo, are you ready? Please go ahead.
Thank you very much. One of the goals of JIIART, as indicated by Professor Shinabe at the beginning of this webinar, is to build capacity in Japan for international commercial arbitration. I'd like to address a few remarks on that topic this afternoon. First, the Japanese Diet passed an important amendment to the Act on Special Measures concerning the handling of legal services by foreign lawyers. I shall call this the Gaiben Act. They passed that act on the 20th of May, 2020. The amendment came into effect on the 29th of August, 2020. The Ministry of Justice's summary of the rationale underlying the amendment states, quote, "There is a need to develop an infrastructure that will promote active recourse to international arbitration in Japan." The ministry then points out that at present, the number of international arbitration cases that come to Japan on an annual basis is conspicuously low. JCAA, about 20 cases. In contrast to those going to Hong Kong, HKIAC, just under 300 cases, and Singapore, SIAC, about 400 cases. That the amendment was passed and came into effect in the midst of the COVID-19 pandemic is evidence of Japan's commitment to the goal of becoming an international dispute resolution hub. The amendment introduces three significant changes to the previous regime governing the provision of foreign legal services in arbitrations. First, it allows foreign registered lawyers to represent parties in commercial arbitrations with an international element. That includes certain arbitrations which, as a matter of first impression, may appear to be Japanese domestic arbitrations. For example, foreign registered lawyers will now be able to act as representatives in a Japanese seated arbitration between two Japanese corporations where one such company is more than 50% owned by a foreign parent company or has a main or head office outside of Japan. Foreign registered lawyers will also be able to represent parties in a Japan-seated arbitration where the law governing the arbitration agreement is foreign law. Foreign registered lawyers will further be able to act for parties in a foreign-seated arbitration heard in Japan. Second, in the past, to be registered as a foreign lawyer, an applicant would have to demonstrate that she or he has had at least 3 years of post-qualification experience, PQE. At least 2 of those years of PQE could be in Japan. Now, following the amendment, an applicant will still have to show 3 years PQE, but 2 of those PQE years may now be obtained in Japan. Third, it will be possible in the near future to establish joint corporations between Japanese qualified attorneys, bengoshi, and foreign registered lawyers, although the foreign registered lawyers in such corporations will still only be allowed to practice foreign law. The amendment to the Gaiben Act also deals with international commercial mediation, but for today, I will focus on international commercial arbitration. The amendment is to be welcomed. It will not produce results overnight, but over the coming years, as more and more persons take advantage of the new provisions, the seed sown by the amendment should generate a growth of international arbitration in Japan. Let me be more specific why I think this will be the case. A Ministry of Justice press release of 12 September 2018 noted 2 phenomena. First, it observed that the youngest ever candidate had passed the Japanese bar exam in 2018 at the age of 19, having passed the Yobishiken, the preliminary exam, in 2017 at the age of 18. More importantly, for today's purposes, the ministry also observed that the number of applicants to the bar exam was the lowest since 2012, dropping by 729 from 2017. The pass rate for 2018 was just under 30%, 29.11%. Of the successful applicants, the majority were male, 1,150 as compared to 375 women. I understand that the trend of a dwindling number of applicants to the bar exam has continued and is reflected in a diminishing number of applicants to Japanese law schools. One reason for the decline in numbers is perhaps that even at 30%, the pass rate for the bar exam is still low. Faced with such a pass rate, many capable and ambitious law students in Japanese law faculties will be discouraged, will think twice about embarking on a further 2 years of law school to qualify as a bengoshi. 2 years of law school will require full-time study of the bar exam subjects to the exclusion of just about everything else. One will basically not have a private life. But why should a young, ambitious student risk potentially losing 2 years of one's life studying for the Japanese bar exam when there is a 70% chance of failure? For many, calculating the costs and benefits of law school, there will be more attractive options to pursue. The reform of the bar exam system has been a point of discussion for many years, and it is not my intention to enter into that debate today. My only point is that the amendment to the Gaiben law gives capable and ambitious law students in Japan another option. They may choose to qualify elsewhere, for instance, by taking an United States, sitting the New York exam, and gaining 1 year of practice experience abroad. Then they can return to Japan to pursue a career in international dispute resolution as a foreign registered lawyer in Japan. The overall pass rate for the New York bar exam in February 2020 was 40%, with the pass rate for all first-time takers at 61% and the pass rate for all foreign-educated first-time takers at 47%. Qualification through the New York bar exam thus offers better odds than qualification through the Japanese bar exam, and on the route just suggested, by way of example, one would end up in any event with an LLM from a foreign law school. But that by itself would not be enough to turn Japan into an international dispute resolution hub. The capable and ambitious Japanese law student will still need to build capacity and experience, skills for handling international commercial arbitrations. Where will she or he gain such experience? True, the student would have had to gain 3 years of PQE, post-qualification overseas or in Japan, before becoming a registered foreign lawyer. Presumably, she or he would gain some arbitration-related PQE experience as a result. But I do not think that this can be guaranteed. I will come back to this in a moment. Even before qualifying abroad, a student would be able to take courses now as part of his or her LLB degree to gain exposure to the theory and actual practice of international commercial arbitration. There are many such initiatives established or now being established in Japan. For example, Keio University offers arbitration-related modules as part of its LLM in global legal practice. A student would become eligible for associate membership, or fellowship in the Chartered Institute of Arbitrators based in London, depending on the number of modules completed. Chuo University is offering a bilingual Japanese and English course in international commercial arbitration practice. Chuo, through one of its founders, Masujima Rokuichiro, has strong connections with the Middle Temple in London. As a result, students at Chuo are able to undergo an intensive training course in advocacy, especially advocacy in international commercial arbitrations at the Middle Temple in London in the course of their legal studies at Chuo. Students at the law faculty of Doshisha University have started Domani, the Doshisha Merton Advocacy Network Initiative, in conjunction with the Hallsbury Society, the Law Students Association at Merton College in Oxford University. Domani, meaning tomorrow in Italian, brings together law students from Doshisha, Merton College, Oxford, and the University of Hong Kong for an intense 3-day interactive workshop on advocacy skills, especially cross-examination, in international commercial arbitration. The workshop is run in English with leading barristers, including Queen's Counsel from the common law world, as tutors. The purpose of Domani is to help today's law students to build their abilities, their skills in advocacy, especially cross-examination, so as to become the leading international dispute resolution lawyers of the future. The inaugural session of Domani took place at Doshisha in September 2019. The second Domani session was supposed to take place at Oxford in September 2020, September of this year, but it had to be postponed to September 2021 due to COVID-19. It is intended to grow the network of young advocates in Domani so that in due course it will comprise students from other jurisdictions, including mainland China, the Philippines, and Indonesia. Domani also has a social component in that it will enable students taking part to maintain long-term contact with each other through social media as their careers develop all over the world. They exchange Facebook accounts, etc. These initiatives may be modest as a start, but with proper promotion, spreading the word that the opportunities to build skills are around for interested students, and taking advantage of the recent amendment to the Gai-Ben Act, the initiatives will add up and in time lead to the building of a sizable core of young, ambitious Japanese lawyers, both Bengoshi and foreign registered lawyers, familiar with international arbitration practice and able to act as seasoned representatives on behalf of Japanese and international parties. In a book which I edited with Dr. Gue Shah of the University of Hong Kong, The Developing World of Arbitration, a comparative study of arbitration reform in the Asia Pacific, we concluded that historically, all attempts to build up a jurisdiction as a successful international dispute resolution system have required support from the community, especially the legal community within a country. I asked a moment ago whether law students coming back to Japan, having qualified abroad, will have enough chances to build up PQE, post-qualification experience, as international arbitration legal representatives. In short, assume that our capable and ambitious law student takes the time, through the initiatives that I have described and others like it, to acquire the skills of an advocate in international arbitrations. Will there be enough cases to go around? I believe that there will be, but we must all work together towards marketing the advantages of Japan as an international dispute resolution center, Japan's strong and impartial judiciary and commitment to the rule of law, Japan's position as a leading financial and economic power, Japan's highly developed infrastructure, including IT networks, and so forth. When law students or would-be foreign registered lawyers apply for internships, law firms, leading law firms, will hopefully be sympathetic to taking them on, even during these difficult COVID-19 times, and even if only for short durations of time, to give them exposure to the actual practice of representing a client, including international clients, in international commercial arbitrations. Arbitral institutions such as the JCAA and TOMAC, and bodies such as the JIIART will need to work hard through webinars, colloquiums, and other events to promote Japan as an arbitration seat. This may entail making an effort to promote Japan in a language other than Japanese, particularly in English. But I'm not sure how else this can be done in a way that will be attractive to persons and corporations outside of Japan. Finally, looking even further into the future, I leave with two other ideas. I wonder, first, in keeping with what I said earlier, whether an international English-speaking chamber in a Japanese court dealing with arbitration-related applications might be something worth considering or pursuing. It would be something in the nature of the International Chamber of the Paris Court of Appeal. Another idea arising out of the future possibility of joint corporations of bengoshi and foreign registered lawyers would be this. There could be this change in the law paves the way for arrangements similar to barristers' chambers in the UK and elsewhere in the common law world. Associations of bengoshi and foreign registered lawyers specializing in the handling of advocacy in international commercial arbitrations. I conclude by referring to one of my favorite Japanese poets from the Heian period, Ono no Komachi, reputed to be the most beautiful woman of her time, but very, very unfortunate in love. She wrote, "Omoitsutsu nereba ya hito no mietsuran yume to shireseba samezaramashi o." Thinking about him, I slept, only to have him appear before me. Had I known it was a dream, I should never awaken. I think with this amendment, we can be confident that Japan's hope of becoming an international dispute resolution hub is not a dream. It is a reality, but it needs all of us to make this reality long-lasting. Thank you very much.
Thank you very much, Anselmo. So I can give you one episode. Ono no Komachi was born in Akita Prefecture, very close to my hometown. So can I change to move to the
Yes.
discussion?
Discussion.
So due to the constraints of the time, we have to move to the next session with no break. I'm so sorry. The next is a panel discussion to talk about arbitration issues arising during the COVID-19 era. So may I ask Colin to be a moderator of this session?
Thank you, Chuck. I now have the pleasure to introduce Professor James to give his talk. James is an arbitrator, mediation and law professor at Rikyo University in Tokyo, and he's a member of the adjunct faculty of the University of Miami LLM program in international arbitration. James, anytime. Thank you.
Thank you very much for the introduction, and thank you so much to the organizers of this very inspired project. I'm delighted to be part of it. I was asked to say a couple of words about international mediation, and then I think our discussion from there will turn to international arbitration. So international mediation, of course, is a very relevant topic, even under the banner of our consideration of dispute resolution related to COVID. There are an increased number of disputes. There are companies who are under financial strains, and mediation may offer the opportunity for a faster resolution and a more cost-effective resolution to those disputes. There's been a lot of activity around international mediation in Japan, particularly over the course of the past 2 years. And one very important initiative has been the creation of an international mediation center in Kyoto. So in 2018, a group of Japanese attorneys who had had good experiences with international mediation felt that it would be useful to establish a center in Kyoto. Kyoto was chosen as the place for the secretariat because, for practical reasons, Doshisha University had excellent facilities for mediation hearings and also space for the secretariat. There was also a symbolic aspect. Japan is known to be a society that values harmony. That's part of the culture. Kyoto is a cultural capital within Japan, and it was considered that it may be attractive for parties to come to Kyoto for amicable resolution of their disputes. I'll quickly add that, like with most arbitration and mediation centers, it's not required that the mediations take place in Kyoto. In fact, just this past Sunday, there was a mediation administered by the center in Osaka. So this is an important development for international mediation. There will be an event on the 20th of this month to celebrate the 2nd anniversary of the center in Kyoto. It will be co-hosted by the Singapore International Mediation Center, and it's open to the public. So if you'd like to learn more, I warmly welcome you to join. The topic for today, though, is the relationship between arbitration and COVID. One consequence of the pandemic, of course, has been that arbitration hearings have moved online. And this has corresponded with historic complaints that arbitration sometimes takes too long and costs too much. And so it offers an opportunity for fresh thinking about what is necessary in an arbitration process. I'd like to identify two different issues that I think would be interesting to explore further in our discussion session. One Dr. Ong mentioned previously, which is the idea of asymmetric hearings. The simple idea is that with an asymmetric process or an asymmetric hearing, the parties do not have to be present at the same time in order for the process to continue. So one application of that might be, for example, that counsel could video record opening statements and make the video recording available to the arbitrators to watch independently of a hearing that comprises witness examination. I think the benefits are plain. This would simplify the hearing. It would also give the arbitrators the opportunity to watch the opening statements in their own time and to watch them multiple times if they wanted, and perhaps to better digest the information before the hearing that's devoted to witness examination. We can also, of course, think about possible disadvantages to a system like this for opening statements. I think the obvious one is that it would not be interactive. So if opposing counsel had an objection to make about the opening statement of the other counsel, it could not be made, at least at the moment, in the moment. Perhaps more commonly, if an arbitrator has a question to ask counsel during the opening statement, or if they want to clarify a point, that also would not be possible in the moment. So this is the sort of thing that might be possible with creative thinking about how traditional hearings could be deconstructed. Another interesting issue for me that has come up when thinking about online hearings concerns witness examination. So if you imagine a traditional in-person witness examination, the witness will wait outside the hearing room until it is her turn, and then she will enter into the hearing room and she will take her seat with the teams of lawyers on either side directly facing the arbitral tribunal. On the table in front of her will be a bundle of exhibits that's been prepared by counsel who will be conducting the cross-examination. The challenge is when bringing these elements onto an online platform, certain concerns are raised. And let me identify a few without going into details that we might take up later in discussion. One, of course, concerns confidentiality, the need to assure that the online platform is in fact secure and private, and that people coming and going from the hearing room on the online platform can be identified. Another concern, separate concern, is about witness coaching or perhaps witness tampering. So when the witness is not in the room with the arbitrators and with the counsel and is remote, there is greater possibility for mischief, in particular coaching on the part of counsel. So that's another issue that has to be thought of and dealt with on the online platform. Another issue that comes up concerns documents. The question that arises is, how are documents communicated to a witness during cross-examination in particular? There's of course an element of surprise about the documents that counsel will refer to during a cross-examination. So the question is how to get the documents to the witness without giving them advance notice of the documents that might be particularly relevant. And then finally, there are of course concerns about technology and assuring that the technology supports the process. I'll leave those as open questions for now, and I look forward to our discussion later.
Thank you very much, James, for that illuminating talk. Our next speaker is Dr. Reuven Bodenheimer. Reuven is an international arbitration counsel and arbitrator practicing from Bodenheimer, Herzberg in Germany. He is ranked as a thought leader in arbitration by Who's Who Legal. Reuven, the platform is yours.
Thank you very much. And from Germany, good morning to everybody, and good afternoon to everyone in Japan and in Southeast Asia. It is a privilege and a great honor contributing here. And as I have only 6 minutes time, let me directly get started. I'm grateful if you could put on my slides and allow me. I have been asked to indeed share some practical considerations, looking back on what has happened in real arbitrations over the last month since COVID-19 has come up. If you please go to the next slide. Some very interesting questions and aspects have been raised by my previous speakers, and I'd like to open by sharing a quite recent decision from Europe, which was issued by the Austrian Federal Supreme Court, addressing issues that many of you probably have seen in recent decisions all over the world already. Why am I sharing this decision? Well, it's one of the first in continental Europe on the question whether virtual hearings are admissible in the constellation where one party explicitly opposes to have a virtual hearing. And the Austrian Federal Supreme Court, in the context actually of challenge proceedings against the entire arbitral tribunal and in the alternative against one arbitrator, stated that indeed when balancing on the one hand the right to be heard with the right to effective legal protection, in these circumstances the right to effective legal protection leading to the allowance of a virtual hearing does prevail. That is, I think, something to be remarked. We will come on, get back to this probably at a later stage. Is it really possible to enforce virtual hearings against the will of one party? But what was interesting, as James has elaborated, the Supreme Court as such shared some very practical considerations and set requirements for the virtual examination of witnesses. And they established that it needs the possibility to observe the person both in a close-up and in a general overview, and the opportunity for each party to record such witness recording. They went further on and shared the following practical recommendations, which is that the witness can be ordered to always look straight into the camera in order to ensure there is no distraction from other sources in the room, that on any given point in time, counsel or the arbitral tribunal must be entitled to allow for 360 degrees surveillance of the room the witness is actually located in, and the witness should and can be ordered to show his or her hands at all times during the examination. Now, if you have a screen like mine, that would look probably like this and pretty ridiculous, but the solution the Supreme Court had in mind is probably just to enlarge the view and allow your hands being visible even when on your table. There are other decisions, but for the sake of time, I have just chosen this one because I think it is not only entertaining, but quite interesting what has been thought about by the Austrian Supreme Court. Now, if I may kindly ask you to continue to the next slide, which apparently is only for entertaining and illustrative purposes, but this is a practical consideration some of you might have experienced as well. There is a research which I found quite relevant in this context. It is rather new if you talk about this with physical scientists. It's a research from 2018 where one actually has evidence that the ability, you could say, of the human eye to concentrate on one point does change 4 times every second. That has an interesting and quite logical reason that in the very old days, not as the sleepy koala we see here, when we climbed on a tree, we could not only concentrate on the tree itself, but had to oversee the entire environment for potential enemies. But that indeed has an impact on our ability, different than following people in one room, to just focus on the screen for an entire day. And some of you will at least internally, secretly agree with me that already following for 90 minutes a talk on a screen is significantly harder than sitting in a room with all these wonderful co-panelists. Now, that leads to my best practice, which I'm sharing with you, is that after the first attempt over the last month of just transforming an ordinary hearing into a virtual one, my best practice is to limit sitting hours to half of a day. We might talk about practical constraints. What does happen if we have a hearing where one party sits physically and resides in Japan and the other in Western Europe? We have an additional cutting the day short because when I start at 7 a.m., it's 3 p.m. at your time, and that leads to my best practice of half-day hearings and ensuring that witnesses are examined only in the ordinary working hours. You can agree with counsel that they may plead and argue until late at night or start very early in the morning, but you cannot request a witness who probably does this for the first time in his or her life to give evidence at 10 p.m. local time in their time zone. Now, please continue to the next slide. Something, again, and I'm not saying this is the best practice, I'm only invited and happy to do so to share my best practice with you. Some of you might pick some ideas up and others you might stick to your best practice. But what has worked, at least in times where there was no strict lockdown, is what I called a hybrid solution between physical and virtual hearings. And that is that I always insisted on the members of the arbitral tribunal traveling and meeting physically together, including the arbitral secretary if there is one, and at the same time allowing the parties to stay in their respective location, and so may the witnesses do. That allows for an immediate interaction between the members of the tribunal. We heard Colin's concept of 3 computers arguing with each other, but this is something which saves money, saves time, but at the same time adds a very fundamental aspect of arbitration, and that is the direct unfiltered exchange of thoughts between the members of the tribunal. A last point, which has been briefly touched upon, and I'm grateful if you scroll down to the next slide, is a very practical one as well. And this is, how do you handle submissions? We have heard this by Anselmo, by James, and also by Colin, how to deal with this challenge in a very practical manner. And here again, Colin has mentioned some providers. We have actually, before COVID, designed and built, and just for arbitration purposes, a cloud service which allows to handle a uniform one joint case file. And that comes to play in virtual hearings with a great effect. And that is that parties easily can access all documents from the same source. There's no misunderstanding. It can be technically easily handled. It's right there, but there's no argument about which exhibit to open, who has to open it, and what do we find once we open it. Much more to say on that, but in order to stick to my time, I kindly ask you to continue to the next slide, scroll down, and that brings me to thanking very much for your attention and encouraging you to raise any questions or continue in more detail on any aspects that you consider interesting. Thank you very much.
Thank you, Reuven, for the very interesting talk. I'll now like to invite Justice Anselmo to deal with the topic of perceived inequality of arms. He's already been introduced as a renowned arbitrator, judge, and professor, but I should also say that Anselmo writes extremely well, and you should look out for his books. Anselmo, the platform is yours.
Thank you. I'm just going to make three short points. The first is that there is no right, I think, to a face-to-face hearing. What one is entitled to under the model law or under the New York Convention is a reasonable, or sometimes it's said full, opportunity to be heard. What is a reasonable or full opportunity to be heard depends on the facts of a particular case. If you have only got access to an internet that constantly breaks down so that the flow of communication with the rest of the world is constantly being broken or interrupted, then it may be that you're entitled to say, because the hearing was heard remotely, I did not have, despite reasonable efforts on my part, a full opportunity or a reasonable opportunity to present my case. That depends on the facts of the matter. That's my first point. The second point is this. James Claxton gave us a litany of shortcomings in online or remote technology use in arbitrations. Now, my court, the SICC, and in arbitrations nowadays, we've been using Zoom technology, largely Zoom, for hearings, including substantive hearings, not just interlocutory hearings. And I confess that I don't find many, perhaps all, of the obstacles or problems identified by James as really problematic or grounds for saying that we should have a face-to-face hearing rather than a virtual hearing. I think all of them can be surmounted. The worst one, perhaps, may be where one doesn't have access in one's home to the internet. But the way we've done that, worked through that, including in difficult jurisdictions, in hearing, say, an SICC case, is to invite the witness who's to give evidence to go to the office of a nearby lawyer who would have access. Now, sometimes that's not possible. If you have complete lockdown or quarantine, that may not be possible. If that's the case, if there's no access to the internet, it's not possible to go out because there's a lockdown or quarantine, then one must bow to the facts. But I think we need to look closely at the objections that James has raised and see whether they're really problems at all. I must say, for instance, that I am very wary of judges or arbitrators who go by demeanor. Colin, in his opening remarks, talked about the dilation of the pupils. Well, I never look at the dilation of the pupils when assessing whether I accept or I don't accept a witness's evidence. I look at the balance of probabilities, and that's really all that one has. We are not lie detectors, judges or arbitrators. All we can do is go by the balance of probabilities and the coherence of someone's evidence. I am particularly wary of those who make very smooth presentations. Colin referred to an imbalance of arms. Someone has a wonderful state-of-the-art remote technology machinery. Someone else has a mere laptop with 4G. Well, I'm very wary of the smooth presentation because I often ask myself as a judge or arbitrator, what lies behind the smoothness? Is it trying to cover up something? So I think we must look twice before we say remote technology is problematic. I hope, in fact, that remote technology is the wave of the future. That is to say, in terms of lessening the carbon footprint of international arbitration, making international arbitration more accessible to all. I think that there's much to be said for remote technology and its increased use, not decreased, increased use in arbitration. The third and last remark is, I think, in fact, that much of the solution to the problems identified by James lies in capacity building. Most of the time, advocates who appear before me in arbitrations or in court waste an awful lot of time making useless submissions or waste a lot of days asking questions in cross-examination. We need to have proper capacity building to train or to develop skills in would-be advocates so that they do not waste time in pointless submission. They get right to the point rather than rhetorical flourishes. And they know what cross-examination is about. So we don't waste time asking meaningless questions, which are completely useless for coming to an award in an arbitration or a judgment in litigation. Thank you.
Thank you very much for that, Anselmo. We now, before I open discussions to the floor, and before I put any questions to the speakers, perhaps I'll let James respond to Anselmo, and we can get the discussion going.
Well, thank you very much. Just a point of clarification. I wasn't raising objections. I was simply pointing to areas that require modification, particular modification and attention in moving to an online platform. But Anselmo has, first of all, I agree entirely with his presentation, and he's already identified some ways that these potential obstacles can be easily overcome. With regard to the appearance of witnesses and the holding up of the hands, another approach is simply to have a camera and assure that the camera is completely against the wall in the room so that there's no possibility for an individual to be behind the camera motioning to the witness or feeding information to the witness. Another solution that some arbitrators use are 360-degree cameras that can actually be operated by the tribunal, and that way they can get a full range view of the room. With respect to documents, there are also ways of dealing with the particular issue I raised about documents used during cross-examination. One simple one is screen sharing, particularly if funds are limited. If the witness is in the same city as counsel, then a courier service can be used to deliver the binder with the exhibits, and the witness can be told not to open the box until just before the examination begins. And there are more sophisticated solutions to the document problem if the amount in dispute is quite high that could involve document vendors. But I think these are some of the practical solutions that I think Anselmo recognizes are available, and I also recognize.
I wonder if I could just respond to what James has said and say something about what Reuven has said.
Please.
In terms of hands. In our last hearing of the SICC, we put out a protocol where the camera could pan the room 360 degrees so that we see that there is no coaching. Well, quite frankly, we never asked the camera to be panned around the room because we didn't think there was much point wasting valuable time doing that. I think, or I would suggest, that at the hands of a skillful cross-examiner, if someone is being coached, it will be readily found out. You just leave Colin to cross-examine the witness for a couple of minutes. It will be very clear whether the witness is being coached or not, or whether the witness has memorized certain things and is constantly going back to a repeated refrain, whether or not someone is in the room coaching the witness. These will be really self-evident, I think, most of the time. In terms of the discovery or disclosure of documents, I actually frown upon documents being suddenly introduced to a witness, Perry Mason style. I am completely against that. So James referred to the surprise element in producing a document before a witness. This is not a soap opera drama. I think that all documents should be shown to the other side at the earliest possible opportunity. Now, there may be some documents that pop up late in the course of a hearing, an arbitration or a court hearing, but I always make it clear to counsel that they should disclose those documents, indeed disclose that they're going to rely or refer to those documents to the other side at the earliest opportunity, and if at the latest on the day in which they are going to pop this document to the other side. So I am very wary of suddenly trouncing upon someone with a surprise document. That is not the style of litigation or arbitration today, which takes a approach.
I think that would quite depend on which court setting we are going to be in, whether it's going to be the English common law courts, Singapore, Hong Kong included, or it's going to be maybe certain US courts, which might have different styles. And it depends on the rules of evidence as well, if it's arbitration. But I agree with Anselmo that it should be in the core bundle, because obviously we deal with 80, 200 bundles sitting behind us. And usually counsel and tribunal like to have a more manageable approach to this and not waste too much time. It's not a memory game. So if it's in a core bundle, it is up to counsel to deploy how he or she wishes to play the game. But a very quick response and clarification to Anselmo. When I referred to the dilation of the pupils, fidgety fingers and body language, that was in conjunction of both the arbitrator sitting there watching lead counsel going for it. Because obviously these are all signs that lead counsel would use to probe and test and look out for signs of where lead counsel is going to go harder in. Usually there will be objections coming up, and the important thing is to allow fairness to be done. So obviously, if it's in a very gray area situation, I'm not sure if the artificial intelligence robots would actually quite understand what's going on. It probably would not be privy to the hesitant pauses, because a pause of 3 seconds or a pause of 3 minutes would probably not be recorded in the artificial intelligence system. So in those situations, I think the human touch will come in more important, and would allow clarifications of objection by opposing counsel. And I think that was where the approach was coming in for.
And if I could have a really short rebuttal, I guess it would be really just a few seconds, just to be clear, because I think this will be public. I was not suggesting that documents be introduced for the first time at the hearing. I was more imagining the situation that Colin was talking about, where there are thousands of documents and the lawyer chooses only a certain limited number to question the witness about and may not want to make those available to the witness with a great deal of time in advance, and may, as is often the case in hearings, want to save it until the examination actually begins.
Thank you. Reuven, do you have anything to add?
Thank you. Well, very brief, 3 points. What Anselmo said, I think I fully agree, and the possibility to use the 360 degrees view and not making use of it is a wonderful example which can be transferred in the old days where we had physical hearings, and we can think of situations where we have certain options but never make use of it because it's standard. This leads to one point, and this is, I think, what we also in the virtual world have always to keep in mind, is the participation of not so sophisticated parties, and even worse, or let's put it differently, more challenging, the not so sophisticated counsel. And that, I think, puts us in a slightly different position, because here we have to ask these questions again and probably have to adapt in our behavior and preparation, different than the examples you gave, Anselmo. They work for a lot of situations, but the requirements are, I'd say, sophisticated counsel and sophisticated parties. The second is, I fully agree with what Anselmo said, that we have a starting point where the fundamental legal framework only requires a fair opportunity to present your case and to be heard. That must be safeguarded. But I think that is not always the legal framework parties are playing on. And if you look in a lot of institutional rules, I think this is a problem we are facing, that it is not clear, or even to the opposite, one might very well argue that by having chosen certain institutional rules, one has a right to a physical hearing. And I wouldn't say that this is the proof of it, but an indication is that the largest institution has recently changed its rules, which is the ICC, which exactly tries to overcome this question mark in their own rules, which allows now explicitly for virtual hearings. And the third point is I must join in Anselmo in the approach as a general attitude, and that is, allow me to stress, to say there are indeed many, many points that need to be considered, but we should be assured that there's nothing we could not overcome when we come to a virtual hearing. Thanks.
Anselmo, I have a question for you. In regards to institutional arbitration, do you think institutions should redraft their rules to cater specifically for the situation of inequality of arms in relation to equipment? What are your views on that?
They could do so, but I don't think it's necessary. If we're right, and the overriding principle is a full, Reuven said, a fair opportunity to be heard, a reasonable opportunity to be heard, then that's a matter for arbitrators to evaluate. And we must trust the arbitrators, the arbitral tribunal, to evaluate it correctly. I don't think we should be holding their hands and telling them how to do their job. Most rules that I'm familiar with simply espouse the principle reasonable, full, or fair opportunity to be heard. And that should be enough for the arbitrator. We should not be micromanaging how arbitrations are carried out. That is not the purpose of arbitration, which is supposed to be robust.
I completely agree with you, Anselmo. There is a voice on the other side, which obviously takes the opposing view, but I'm with you on that. James and Reuven, what are your views on that topic?
I regret that I agree with both of you, so I don't think I could take the conversation much further.
Yeah, Anselmo, you please correct me, but indeed, I think there is not really a different view on it. I think we agree on the general framework. However, by the way, the concept of the reasonable opportunity to present your case, I have taken, which I very much like, in deviation from the model law, from the most recent change of the Hong Kong arbitration law, which indeed, I think, makes it clear that it's sufficient to give a reasonable opportunity rather than a full one, which adds significantly to efficiency, I believe. But yeah, again, I think I made it clear. It's a case that needs to be argued, and there is a lack of clarity as to whether one party can insist on holding a physical hearing. I think it is mainly driven by the question, what have parties agreed to? Allow me to give you one example to support my case. I think it's getting quite difficult if not only parties have chosen a certain set of institutional rules, but for example, which we see in practice, if parties have agreed to the arbitration institutional rules in the version of 1989. And so then we have a different balance we need to take, you know, the express will of the parties. In this version, there was clearly no reference to any virtual hearing whatsoever, and effective proceedings on the other hand in times of COVID. And there I think it's getting difficult. And in this regard, I think institutions should consider to update their rules, yes.
Moving on to a different topic, James, earlier on in your presentation, you were dealing with mediation, and I wanted to ask you whether the ratification of the Singapore Convention, if that was ratified, if it would promote growth of international mediation in Japan.
I believe that it will, whether or not it's actually used commonly as a tool to allow the enforcement of a settlement agreement. I think it will send a very clear signal to the international community that Japan is serious about international mediation and is ready to give this special legal significance to settlement agreements that result from mediation. So I think simply as a message, it's an important step.
Could I raise two observations in relation to what James has said? One is note an observation made, I believe, by Professor Dogouchi, Professor Masato Dogouchi. And he suggests that in terms of Japan acceding to the Singapore Convention, there may be difficulty because what the Singapore Convention does is privileges mediated settlement agreements arising out of international commercial mediations. But domestic mediated settlement agreements, that is, non-international mediated settlement agreements, will not have such privilege. If Japan accedes to the Singapore Convention, Japanese domestic mediation agreements will not be privileged in the same way. And Professor Gochi points out it may be a hard sell to Japan to say that, well, we should privilege international commercial mediations, but not privilege domestic mediated settlements in domestic mediations. And there are a lot of domestic mediations in Japan. That's the first observation that may be special to Japan, but it may be special to other jurisdictions. The second observation is more general. Writing, I believe, in the Chartered Institute of Arbitrators newsletter or a blog, Justice Hamid Sultan of Malaysia, of the High Court of Malaysia, has queried whether the Singapore Convention may increase the opportunities for money laundering or other such serious crimes activities. The problem, as I believe Justice Hamid Sultan identifies it, is that if you are, anyone can claim to be a mediator. Anyone can claim to sign a mediated settlement agreement, an international mediated settlement agreement. but that could be just a put-up job between two parties in order to give color to a money laundering transaction. So Justice Hamid Sultan says, well, one must think about this. It's not fatal. There are ways to deal with it, but one must think about this, and one must perhaps establish some sort of system to run side by side with the Singapore Convention in order to minimize, perhaps not, it may not eliminate altogether, but minimize or mitigate the possibility of using the convention to further wrongful activities.
That was a very insightful article by Justice Hamid Sultan, which I agree with. There is this money laundering issue, which I'm not sure how the issue can be plugged, because I don't think that came into the mind of the drafters at the time. But it is quite an interesting one, and yeah, I urge the participants to Google it and find the article, Chartered Institute of Arbitrators, sometime last year, and read it for yourselves.
One possibility of dealing with what Justice Hamid Sultan was observing would be this. Actually, we have in place today a system very much like that contemplated by the Singapore Convention, and it's been around for, what, possibly 1,000 years. That's the notarial system. Once you are qualified as a notary, you can give a notarial certificate to particular documents, especially in conjunction with the Hague Apostille Convention of 1961, and that notarial certificate will be recognized in other parts of the world, especially when accompanied by an apostille. What we do for that is we set certain requirements in order to be a notary. Now, the Singapore Convention doesn't actually define who is or who is not a mediator. That is presumably left to the legislation, to the legislation of each country, so that one can have an international understanding about the minimum qualifications of a mediator for the purposes of the Singapore Convention, just as there is, more or less, as a result of the development of notarial practice over hundreds of years, there is a minimum understanding of what it takes before you can claim to be a notary who is able to certify things which will then be taken at face value in other jurisdictions.
Allow me to quickly add two provocative points. The one is, with this concern, what is the difference between the enforcement of such mediation settlements and choosing ad hoc arbitration for the very same purpose? And the second provocative point is when we talk about the Singapore Convention, besides the marketing aspect, has any one of you, by reconsidering the core concept of mediation, faced a situation where one had to enforce a mediation settlement?
Perhaps I might respond to Reuven. I think his second point is quite a good one. We mustn't let the tail wag the dog. With arbitrations, with judgments, the standard statistic that is put out is that they are judgments or awards are honored in 90% of cases. So we're only talking about a small percentage where enforcement of an award or a judgment will be in question. Mediated settlement agreements being voluntary, we must presume that it's a greater percentage of mediated settlement agreements that will be honored. So actually, we're talking only about a very small percentage of mediated settlement agreements, a very small number of cases where hopefully the Singapore Convention will be called upon. So we have to keep all the problems in proportion. The second point, or the first point that Reuven referred to, was ad hoc arbitrations. Now, ad hoc arbitrations, let us take a common example. Most maritime arbitrations, shipping arbitrations, which are typically for relatively small amounts, $100,000 is already a significant maritime arbitration. Most maritime arbitrations are ad hoc arbitrations. And they've been taking place for, again, centuries without any problem. However, there have been a number of people who have noted recently that arbitrations, perhaps ad hoc arbitrations, can be used as a means of money laundering. So one has to guard against this. And I think the safeguard there would be the arbitral tribunal. The arbitral tribunal must constantly be on the alert that it is not being used to foster illegal activity. Under Hong Kong law, for instance, under the Hong Kong Organized and Serious Crimes Ordinance, everyone is obliged, if something smells like money laundering, if there is a possibility that something is money laundering, then you are under an obligation to inquire further. You can't just turn a blind eye. It is a criminal offense to just turn a blind eye and ignore that. So I think arbitrators would be under such a duty, and it may be that some such law, similar to the Organized and Serious Crimes Ordinance in Hong Kong, in all jurisdictions, making sure that arbitrators are aware that they can't turn a blind eye to signs of manipulation of the arbitral system, whether ad hoc or institutional, may be a good idea.
I think it's difficult to enforce because of the very confidential nature of arbitration. And I think it comes back to this age-old debate as to whether an arbitrator should be like a policeman to look beyond what he or she has been appointed to do. But I do agree that if it's very obviously a money laundering scheme, the arbitrator should be very careful and should act appropriately. Quite often it's very difficult to do this, to detect such issues, particularly if both sides actually do appear to contest positions, and even more so if they appear to engage lawyers and even credible law firms to do that. But I think the danger of money laundering in arbitration is much less than what we spoke about earlier, and Justice Hamid Sultan's concern about the danger of money laundering under the Singapore Convention. I think it's quite difficult to pass any domestic legislation to define who can or cannot be a mediator. The whole point about mediation is it's meant to be more user-friendly, less formal, and the village headman can also be a mediator. He doesn't have formal qualifications to do that. So I think that's where the main problem lies. But deeper than that, it doesn't get around Justice Hamid Sultan's point about it's only the mediator who oscillates to and fro the parties, and who knows what the parties really did say, what the mediator really did say. And I think that'll be quite interesting to watch. And I'm sure we're going to have a lot of cases on this. But I wonder whether it takes an amendment to the Singapore Mediation Convention itself to fix the issue.
I would also perhaps raise a note of caution about any kind of certification process. It makes me think of the history of the New York Convention. And one of the innovations of the New York Convention over the Geneva Convention of 1926 was that it did away with the requirement that awards be certified at the seat of arbitration before they could then be enforced.
Well, question to you gentlemen before I open up to the floor. The COVID-19 pandemic in general, is this a chance or is it a threat to international arbitration? Anselmo, your view first.
I don't regard it as either a chance or a threat. It's simply a reality. And international arbitration has contended with that reality and contended rather well. The response is not perfect. It's constantly being refined, but that is good. It means that international arbitration has not been complacent. Where I believe that COVID-19 will put a real premium on is mediation, especially commercial mediation. If mediation is successful in 70% of cases, given the financial recession that apparently is coming or has come in the wake of COVID-19, long, expensive arbitrations, long, expensive cross-border litigation is not sustainable. What one would need to resolve disputes is international commercial mediation, cross-border disputes. So I think international commercial mediation comes on its own in this COVID-19 era.
James, your view?
I hate to agree with Anselmo, but I fully agree that this has a lot of potential for international commercial mediation. And it also, I think, is a great reckoning of arbitration process in general. I mean, historically, if you follow the Whiting case, Queen Mary reports, people are unhappy with how long arbitration takes and how much it costs. And so just in moving on to an online platform, I think that a lot of assumptions about how process should work are being put under the light. And I think that may lead to efficiencies in terms of cost and time.
So we get rid of the due process paranoia and move on to a world without any fears of allegations of unfairness.
That sounds kind of idealistic.
Ruben, what are your views on all of this?
Well, at least just for the sake of shaking our harmony, I will disagree. and based this on two reasons. The one is, indeed, I think it is a chance because it gives arbitration practitioners and the arbitration community the opportunity again to show how much better we as practitioners can adapt to the challenges we face in comparison to the alternative, and that is state court litigation. And that is an observation I can clearly make here, specifically in continental Europe, where in many countries you do have a great functioning judiciary, which is not able to cope with the challenges that we are facing. And the second reason is indeed something you just have very briefly struck. I think it is a wonderful chance and it's a great opportunity to overcome a large problem that we have been facing for the increasing numbers over the last years in arbitration, and that is the ever-growing concern of being challenged or being set aside for not sticking to a very, to my view, very abstract artificial concept of fair trial and the right to be heard, which has in practice mostly misused to actually apply guerrilla tactics and delay process. And this now actually allows us to really get back to the concept of efficiency and practicability. Therefore, I strongly believe it's a great chance for arbitration.
Thank you. Now, there's also, interestingly enough, because we're all running on virtual platforms these days, and we encounter situations where we have arbitrators strewn across many different time zones, and counsel are also across different time zones. And usually we end up, some people will end up starting an arbitration at 7 p.m. and ending way past midnight in the wee hours of the morning. Now, what are your views to a proposition that I have where obviously there has to be flexibility in arranging for sitting times, but the suggested dominant time should be at the seat of the arbitration. And the reason being, usually it is at the seat of the arbitration where people engage transcribers and various service providers, and because it's a dominant point, it should take precedence. What are your views? Perhaps James, you go first.
Sure. I would actually disagree. I completely follow the reasoning, but I think the choice of the seat of arbitration is, of course, distinct from the choice of where the hearing will actually take place. I think a more global approach should be taken that is fact-specific. including the location of witnesses, because I think that maybe the witnesses are the least familiar players in this arbitration game. And so maybe there should be some deference given to where the witness is located and to managing time around that to the extent that it's possible.
Anselmo?
I think arbitration is different from litigation. With litigation, a witness may be compelled or to appear and to give evidence. In arbitration, a party gives evidence because a party wishes to do so. A party gives evidence in support of a particular side's case or against that side's case. So I would be less flexible in arbitration, I suggest. That is, I would take the principle that you, Colin, have put forward. The dominant time is the time at the seat of the arbitration. And witnesses, to the extent possible, will be accommodated. But sometimes it may not be possible to accommodate their time zone, in which case they will have to chime in with the time in the seat of arbitration. In the past, in the pre-COVID-19 era, which looks like a century or so ago, people used to fly around in airplanes. They suffer time change. They can take long plane rides and have to engage in expensive hotel rooms. I think it's a small price to pay for that one has to stay up at night in the middle of the night, or one has to get up much earlier in the morning in order to give one's evidence, rather than take a long plane ride or sleep in an unfamiliar hotel room for days on end. So I think on balance, your principle should govern, to some extent accommodate, but if it's not possible, it's not possible.
So Reuven, will you make it a tie or will it be 3-1?
Thank you. No, I think there's not much I can add. I think parties have taken already a choice when they agree on a seat. We have this outside of virtual hearings already, when we have to determine at which midnight do you have to deliver a submission and hand it in. It is usually the time of the seat. That is a good example where I think we all agree that might lead to one party having additional 7 hours and another having less hours on the day of submittal. And a similar concept must apply for witnesses if one can't reach consent. However, I have also understood Colin's approach that, of course, this should not lead to automatically forcing people to stand up in the middle of the night. It's just an indication of, if parties can't reach any agreement, how one could solve such a situation. And there, I think that's a very good approach.
And Reuven, I think earlier you discussed about having members of the tribunal get together, and witnesses can be in different parts of the world and counsel can be in different parts of the world. That would assist in saving costs, I think, but it maintains the efficiency of the tribunal as a whole. I think that was a position you had taken earlier.
Yes, that is correct. That's a suggestion, and I can say it's not only an abstract suggestion. I had already 3 hearings which followed my proposal. I must say all 3 of them were such that I was an arbitrator. I have not thought it through whether this would be something I really considered as extremely essential when being counsel, but I think the experience I made as arbitrator is that is a very good approach. And you may all differ, but I think this, these dynamics, which I always describe as a micro mediation, this microcosm among the arbitrators, the necessity really to exchange both on the merits on an intellectual level, but also to ensure that the chemistry is right among those who have to write and decide on matter. This is really essential. And I think You have sometimes situation during cross-examination, during a pleading, where you have the need there to say, please look at this exhibit. What do you think about this? Should we ask him something? Have a look here. Or I don't understand it. Do you understand what she or he is saying? All those things, I think it's very difficult to manage them when the arbitrators are not physically together. Again, it's a matter of practicability. I can tell you we are currently preparing another hearing with Southeast Asian Council and a colleague from China. We are trying to investigate airports which have a hotel in the transit area, which would allow, that's the approach, that no one has to enter any country and consecutively no one is subject to quarantine. The problem is it's a rather long hearing and no one wants to spend 2 weeks in the transit terminal of an airport. That speaks against it. But yeah, I believe, and again, I'm happy to hear your views as this was my proposal. I think this is something that one might consider for even outside COVID or after COVID times as a very efficient compromise between physical and virtual hearings.
For me, I'm fully behind Reuven's suggestion. I think it's very important for all three members of the tribunal to be together, because it's the tribunal's interaction that really counts, and questions that are to be put out to players on Zoom and Epic platforms, for example. Usually the tribunal can discuss behind the scenes. I think that's very important. Anselmo and James, what do you gentlemen think? Anselmo first.
I don't think it's really necessary, because in other hearings we take advantage of the Zoom breakout room facility, and so the arbitrators or the judges in litigation discuss amongst themselves. Now, one may not be confident about the security or confidentiality of the Zoom breakout facility, or something might go wrong and someone might accidentally press the wrong button, and so that the parties or one party or other gets to hear what the discussion is about. Another way to do it is to discuss through a separate dial-in facility, or through app, or through, if you're doing it with a Chinese party, WeChat. So I think there are ways to get around this. It will not be, the post-COVID-19 era need not be exactly what we had before. What we had before has imperfections as well. So I think that we have to live with some differences that may not be the most ideal, but may be far better when you consider other factors, maybe much better than what we had before.
Well, on that point, can I invite Mr. Yoshi Takatori to chime in? He had sent me a message on the chat room. How do you deal with issues of neutrality of arbitrators when you're dealing online proceedings? Perhaps, Yoshi, can you... Yes, thank you.
Yeah, thank you very much. First of all, I really appreciate this great session as the one of the executive director of the JIIART, and very, very informative. So my question is related to such kind of, the arbitrators deliberation and something like that, but especially for practical aspects. For example, like, in-person arbitration, usually the party appointed arbitrator is not sitting next to the that parties, and the other parties appointed arbitrator shouldn't sit next to the such arbitrator. So, but online, for example, like if JIDRC is utilized for the kind of a hub arbitration hearing facility in Japan, where the Japanese parties and such party appointed arbitrator is located, and Singapore and Maxwell Chambers, the Singapore parties are physically there with their appointed arbitrator or something like that. In such case, one idea is should be like even inside Maxwell Chambers, the such party appointed arbitrator should be in a separate room from the such party or something like that. I mean, it's quite practical question, but recently the such neutrality and independence and such appearance is quite essential. And I remember 3 years ago something at the ICA conference, the Justice Menon pointed out such quite concern on the such neutrality issue or something like that. So I'd like to ask you on such how to resolve make a such kind of practical resolution for such appearance or online characteristic proceeding, especially in terms of the party appointed arbitrators location. That's my question. Thank you.
Well, since Reuven and I want to sit together, I think the answer has to be answered by Anselmo and James. So James, you go first.
I think that speaks to the importance of thinking about the issues at the outset of the arbitration and drafting a protocol which addresses all of these points so that there's a common understanding among the players in the arbitration about how things will proceed.
Anselmo?
Well, I go back to what I said previously. It seems to me the most economical way of dealing with Professor Takatori's scenario is for the 3 arbitrators, including the chairperson, to attend the arbitration remotely, rather than to hire another room in Maxwell Chambers or to hire another room at the JIDRC in order to hear the arbitration. I don't really see that you're losing very much by the arbitrators hearing remotely. So I would find that the problem is best resolved by all 3 arbitrators just hearing the parties remotely, and they don't have to hire a room in Maxwell Chambers or the JIDRC. They just use their solicitors or their lawyer's office in order to make their submissions or adduce their witnesses. So I think we can do it much more economically and much more practically if there are concerns about impartiality.
But let's increase the stakes. It's now $1 billion US, basically, the dispute, right? So disbursements are now a drop in the ocean. And Yoshi is very concerned because his party is concerned that the other side might not be playing fair, and there's $1 billion US at stake. Now, usually when the 3 arbitrators meet, they also have a chance of pointing out various documents to each other to say, oh, have you looked at bundle B, page 281? Have you looked at this document? What do you think? It's very difficult to do this. You can do this, but it's difficult to do this on Zoom because then the other party would say, well, I think I've got this document, but I need to search for it. And, it wastes a lot of time. I think at the end of the day, it depends on the size of the claim. Obviously, if the claim is a small 1 million US claim, it's quite different to a claim that's 500 million US.
I would beg to differ. I would think that the principle is the same, no matter the size of the claim. In terms of exchanging documents, or again, exchanging between arbitrators, I don't think we've ever had any problem in the Zoom arbitrations I've done or in the Zoom litigation that I've heard. We have successfully exchanged documents and remarks beforehand, either immediately before the arbitration hearing or the judgment hearing, or 1 or 2 days beforehand. So I don't think there's any real problem.
Let me rephrase. I think I wasn't being particularly clear, and apologize for that. We're talking about costs because I think you were quite concerned on the issue of costs. And so what I was saying is that obviously if it's a much larger case, issue of costs, hiring another room, another 3 rooms at Maxwell Chambers is just a drop in the bucket.
Yes, but it's not an excuse to be extravagant.
Reuven, any last words on this point? You brought it up.
Well, apparently gives food for a discussion, which makes me happy. Well, again, I think to conclude, there's no real discrepancy between the views. It's a very reasonable approach by Anselmo to say, yes, it is possible. It is possible However, I think the dynamics, and I hope you can agree with me on that, Anselmo, in a physical hearing, there are more dynamics than just saying, can we have a short break? We want to discuss. It's, I don't say that always happens, but very often you do have interaction, verbal, but also non-verbal among the arbitrators during a hearing. There's something that comes up, you look at each other. There's something you really want to clarify without making a break, without interrupting cross-examination. You want to physically point on something. All these things, this is the one reason why I think it is really a good investment, and where you want to ensure that this is possible. And the second is, as long as we have awards written and decided by human beings, and as long as we're not talking about the sole arbitrator, when I put myself in the shoes of being counsel, I always consider it as relevant not only to find the right arbitrator for the specific case, but if I, for example, represent respondent, to find the right arbitrator that suits to the one already on the bench. Because I strongly believe if they can match with each other, this will add to the efficiency and the good conduct of the hearings. And therefore, we must promote and help the arbitrators to get in the best exchange personally as possible. Therefore,
any last reports, Anselmo?
Nothing else to add. Thank you.
So Yoshi, I hope you appreciate I've been as deliberately provocative as possible to get my fellow panelists riled up. And
thank you very much. Actually, as the advisory board and chair of the JIIART, I'm the chair of the JIIART's online web hearing committee. So all today's discussion is very, very helpful, as well as the Singapore Convention's concern on the money laundering. That's kind of shocking, but we should take care of it. And we are now discussing with the Japanese government on how speedy we should sign on it, but we should overcome such concern as well. So really appreciate the everyone's discussion. I really appreciate the Anselmo, James, Rubens, and Colin.
Thank you very much.
Thank you. Thank you very much.
thank you.
I think Professor Abe, Professor Ito will now draw this proceedings, this conference to a close.
Thanks a million to all the panel for such an exciting. Oh, sorry. I'm so sorry. Thanks a million to all the panel for such exciting, collaborative in part and intelligent discussion. So unfortunately, the time to close this conference. So I'd like to ask Kosugi Sensei for the closing remark. Kosugi Sensei has been the president of the Law Asia for since
1997, the former president.
So long ago. And he is one of the strongest proponents for internationalizing Japanese legal practice. This is very sorry for the surprising. Please go ahead.
Yeah, thank you very much for the very lively and heated discussion. It is sad that we have to close the session. 2 hours have already passed. I myself attended yesterday's session and today's session. And yesterday, among Japanese speakers, we discussed or more focused on the Japanese situation. But today, by the participation or contribution of foreign speakers, we can discuss the situation from more broad aspect. And I'm very much impressed. I have been in practice for more than 50 years, but now that really the COVID-19 situation is new, but I feel this is really a challenge, and we can cope with this problem or situation by mutually discussing, and thinking about the future. And listening to the discussion today, I really feel that our generation's obligation to encourage the young generation, the next generation, there is a very big chance, a big market in arbitration and mediation, and how we can support them is very much important matter. And JIIART is one of the purposes to educate, to train the young generation. I'm very much convinced that the importance of that task. Like that, all of you can continue to support our program and continue to support the Japanese lawyers. Thank you very much.
Thank you. I'd like to talk about a little bit at the last moment. Thank you very much, Mr. Kosugi. I'd like to talk about a little bit about JIIART. You can go to JIIART, J-I-I-A-R-T website, and you can find lots of information from there. So from the now, you can go and become our friends and communicate each other together. And I hope we can hold our next seminar next year without, or I'm not sure still, COVID-19, but we can go forward with all of you, and we talk to you soon again. Thank you very much today. And thank you for the panelists and moderators. Thank you very much.
Thank you.